I'm Byron Botras, the founder of EZ-Probate. I want to thank you for starting a questionnaire. The first question is very easy. All we need to enter is the name and the state and where the deceased resided. Here we're simply asking if you're the petitioner or are you filling this out for somebody else. Here we need your information as the petitioner. And now we need to know, are there more than one petitioner? It is not necessary. In fact, we often recommend that only one petitioner be on the form, and that just simply eliminates the multiple signatures that are necessary for the petition. The court will want to know if there was another name the deceased was known as. Oftentimes, nicknames are used as people's legal names, or if there is a shortened version of their name. We simply need to know if there's probate been opened before, or is this the first time you're filing for probate for the deceased. Just need to know when the deceased was born and when did they pass away. The primary residence of the deceased determines the jurisdiction in which probate needs to be filed, both from a state level and a county level. If the deceased owned real estate in a different state other than the place where they resided, a different probate case needs to be opened, as the jurisdiction of probate is determined by where the deceased resided and also where real estate is located. Many courts want to know where the deceased passed away. If the deceased passed away in a hospital or a hospice or some other location, please indicate so in the questionnaire. The courts do need to know if the deceased was a U.S. citizen or not. If the deceased was not a U.S. citizen, please mark it on the questionnaire. If the deceased had no will, that is called intestate. Intestate is simply when there is no will, and now the state law determines who the heirs will be. If there is a will, then the will determines who the heirs will be. The courts do need to know if the deceased had a will. Note, if you have the original will, that's the most common situation. If you only have a photocopy, that is still okay. There just might be additional paperwork there that is needed. If you only have a photocopy, please let us know in the relevant circumstances. If there are anything unusual about the will, you can put that under relevant circumstances or exceptions. Many states require that the witnesses of the will also sign an affidavit attesting that this is the will. Other states do not require this. So if you do see a witness, please let us know. Also keep in mind that many wills, it is virtually impossible to make out who witnessed it because it's just a signature. So if you don't know, that's perfectly fine. Again, there might just be additional paperwork needed if you cannot identify the witness. A codicil is a modification to a will. It does not revoke or replace the original will. It simply changes one or more aspects of the will, and it would be signed and dated just as a normal will with the original signature of the person writing the will and witnesses. Here we are asking if you are the executor of the will. Again, anybody can petition the court for probate. The executor is the one that needs to be named in the will, and ultimately that is who the court will grant authority to. Are there any additional executors, co-executors in the will? A successor executor is one that's named in the will in case the original executor cannot act. Again, here we ask if you have the original will or have access to the will. Note, under some circumstances, the attorney might have the will, or the will is located in a safety deposit box. If you know that to be the case, there is a special order from the court where you can have the power to retrieve the will from the safety deposit box, or on the rare instance that the attorney refuses to give you the will. Here we're simply asking if any of the following circumstances apply. Probably the only thing that can really complicate a probate case if you have a troublesome family member that's going to fight every step of the way. If you do find yourself with a troublesome family member, don't worry. It's very rare that they actually can cause any harm to the estate or complicate matters. In the rare instance that they do bring a lawsuit to you, that's when you probably will need an attorney. We do need to know the marital status of the deceased at the time of death. This is because many states have very specific protection clauses for the surviving spouse. It's important to know if they had any children. These would be natural or adopted children. And please indicate if the child is an adult, a minor, disabled, or has predeceased. If there is a child that is disabled, we do need to know the guardian. If the child is predeceased and the child had children of their own, it is important that we know that too, as state laws will also mandate that those children be notified, or they would stand in to the predeceased child's inheritance. If there is anybody outside of the immediate family named in the will, please let us know. It's very important that we know a good guess of the estate. It's not important that you know exactly the size of the estate. The reason we need to know is most states have a small estate threshold that if you're under that value, you can qualify for very simplified procedures. And also the court fee is oftentimes determined by the size of the estate. The personal property are all the things that a person owns. These are the things, not including real estate, that both you can touch, like a car, golf clubs, jewelry, or the intangible items like bank accounts, investments, royalties, or any other type of financial instrument. It's very important to know if the deceased had real estate. If there is any debt, please let us know. We also need to know if the real estate produces any income. Essentially, is it rented? And the last question is very simple. Are there any other outstanding debts outside of the real estate? Once you're finished, simply press continue and you'll be taken on to the next step. Now that you've finished the questionnaire, you can view the preview of the petition or go ahead and click and pay now and you will get the full packet and instructions. You can always go back to any section and change any answer or update any answer. If everything is marked complete, you're ready to move forward.